Hello, everyone. Welcome to this new webinar. We're here with attorney Cynthia Milian, and we're going to talk about defending against deportation relief options in 2025. So Cynthia, she is a senior associate attorney at Powers Law Group. She has been, well, if you can go to the next slide, please. Yeah, she has been licensed since 2008.
2018.
2018, sorry. Well, she began a legal career at Powers Law Group in 2018 too, and she has been an advocate for immigrant rights and passionate community leader. So, well, Cynthia, the word is yours.
Thank you so much for the introduction, Maria. So we're going to go through and talk a little bit about what you can expect right now in the current immigration and political climate. This does not encompass all of the forms of relief that are available, but some of the major ones and just some major updates of some relief that is currently available. So the overview of the 2025 enforcement climate. So immigration enforcement, as you're well aware, has significantly climbed and intensified in the past few months since we have the current president come into office. And so there's different executive orders, different internal memos and mandates where the Department of Homeland Security has to meet certain criteria and quotas of the number of people that they detain. So we've seen certainly that it's not just people that with criminal records that are being detained, but people that maybe have any sort of anything short of being a U.S. citizen and even a permanent resident, you could be subject to getting detained. And so what we've seen is that it's continuing to increase, intensify all across the U.S. And it doesn't help that recently a bill was passed, one big beautiful bill where more money is being given to ICE and for their different, their different operations to continue expanding and increasing the number of deportations daily. So it's something that we have seen. It's very unfortunate, but we do, as a reminder, we do removal defense here in the firm. So if you or a family member happen to be detained, reach out to us for a consultation to see if that family member, that individual qualifies for a bond. And it's not only that, but there's also case law that even makes it more complicated now for people to obtain a bond. Cases such as matter of QLE, where it basically takes away an applicant's right to even request a bond. So these are all things that an attorney can analyze in advance to let you know whether or not there's a chance for that family member to request or qualify for a bond. Temporary protected status. So as you know, the current administration has moved to terminate a lot of TPS for many different countries. And one of the biggest ones that we see is going to terminate soon, it was supposed to terminate in early July, but it's been extended to September 2025, is for individuals from Honduras, from Nicaragua. And we're seeing that soon it's going to come for other countries as well. We're just seeing the different challenges going back and forth on the termination of these different temporary protected statuses. But one thing that you can do now is to consult with an attorney. If you've been living here for more than 15, 20 years and maybe have a family member that is a U.S. citizen or resident, and if you have the proper entry into the U.S., and you may qualify for something that's called adjustment of status or applying for permanent residency, which is the same thing. So, or consider anything else, any other creative method for which or by which you can remain in the U.S. legally and having that work permit. So now's the time to consult with an attorney to see what alternatives are available for you before September 3rd, 2025, if you're from Honduras and Nicaragua. Other things that we've seen is there's not a lot of people entering the U.S. right now at the border. CBP-1, the app that was used for individuals to present themselves at the border, get a credible fear interview, all of that was done away with under the current administration. However, there's still people that may be able to be subject to a credible fear, or people that maybe are here already that were released under parole in the past, and they've been given all sorts of different documentation that shows maybe they were expedite removed, or maybe they never went before an asylum officer to do a credible fear. So credible fear is basically what starts, if you're able to pass it and establish that you have a credible fear, it starts the proceedings for you to request asylum. Now, that is very general because there's a lot of other things that may be applicable to you, especially if you entered in the past year or 2 years, if you're subject to something called circumventing lawful pathways, where you may not on its face be eligible for asylum, but you may have to overcome some criteria in order to qualify for it. So it's very important. I know that we've recently been hired by a couple of people to prepare them for these credible fears, to establish, why it is that you can't return to your home country based on a protected ground, and how you can eloquently explain that to an asylum officer if you are in the process of getting interviewed or expect to be called for a credible fear interview at any point. Another thing that you can consider, again, there are many different forms of relief available, where we're doing some high level ones that are maybe not very common for people or for people to look into. So a U visa, if you have been a victim of a crime here in the US, if you've assisted the law enforcement or that agency that has filed charges against the perpetrator, then you may qualify for a U visa. And this U visa can open up an opportunity for you to request a work permit and eventually apply for residency. But it does take a long time. It could take anywhere from 10 to 15 years because of the number of visas that are available on a yearly basis. So you have to be a victim of a qualifying criminal activity. So it can't just be a simple assault, right? And this is, again, general. Every case is different. There's another component in the assault that maybe elevates it to something where you can qualify it as serious bodily injury, then maybe you can make an argument that it qualifies for a U visa. But the first part is victim of a qualifying criminal activity. You have to have assisted the law enforcement or the prosecution or the prosecutor in the agency or jurisdiction in which the crime occurred. So you must demonstrate that, because you have to go through that agency. They must certify the crime that say, you know what, Cynthia was in fact a victim of this crime, and she was available to testify, came in and helped us identify the individual. So now we're going to sign off on this. That is the first step. Once you have that, then you apply for the U visa, and you have 6 months to do that. And then it's just a matter of waiting, right? Waiting for a work permit if you're able to get it, and then waiting until there's a visa available for you to apply or, to qualify for the U visa. Once you get that, then you're eligible to, you've been in the US for a certain amount of time, then you can apply for residency. So it's a long process, but it's one where you and family members, derivatives, can even benefit from it. So if you have a spouse that's not here, that is here without status, you have children, all of you can become U visa derivatives as well. So this is something to look into. And don't discount the type of crime for which you've been a victim of. A lot of the times there are certain factors in it where you can get creative and pull some of the law to see how it can, help you in your request for a U visa. So certainly talk to an attorney. There's also the T visa for individuals that have been victims of human trafficking. So for example, if you've been trafficked, based on forced labor or sex trafficking, then if you can demonstrate those things, through testimony, and if you've tried to file a report with the FBI, then you can qualify for this. So we've had a couple that have been filed, and the same with the U visa. It eventually leads to a green card. And with the U visa, because not many people apply for it, it's relatively faster to go that route. So also consider that. NACARA, this is very applicable to just a very small group of individuals, but there's people still out there that may not know about it. So certain Central Americans can apply for NACARA to stop their deportation, to obtain status. And this is for nationals of Guatemala, El Salvador, who entered before late 1990 and registered or applied asylum by early 1991. So there could be derivative eligibility, and you have several documentations that you have to apply for, but it looks like maybe the grace period has already ended at this time. But certainly talk to an attorney to see if there's anything else that you can do. So DACA, we've seen that the deferred action for childhood arrival is deferred action for childhood arrivals is in the news a lot. Bottom line, it's legal here in the Fifth Circuit. It's still valid for individuals in Texas, which is, where we're practicing here in Houston. However, we represent individuals all over the U.S. The biggest thing is it's still valid. You can still request your renewals. You should file those timely. Try to file them between 3 to 4 months in advance. You can file them electronically as well. And we've seen a quick turnaround in the renewals for that. As for first-time applicants, I know that in some jurisdictions, it's a little bit unclear whether or not you can do it, but we continue to monitor litigation and updates to see when that can be a possibility for individuals that live outside of the Fifth Circuit or that live outside of, Texas, Louisiana, to see if maybe you can apply for that. Well, there is also something that was instituted by the current administration from the Department of Homeland Security, where it incentivizes individuals to self-depart instead of as an alternative to forced removal. So it offers travel assistance and exit stipends. If you're not wanting to live here anymore and you're afraid, then this is something that you can look into and consider for yourself. All right, so there's a lot of litigation going on all over the U.S. and injunctions affecting relief. So for example, litigation that's pending over the termination for the temporary protected status for individuals that are from Honduras and Nicaragua. And there's just so much happening even for individuals that maybe get something that's called withholding of removal, or maybe they don't qualify for asylum. They qualify for withholding of removal, which means that a judge still issues a removal order, but they won't send them back to their home country, where we're now seeing that the government is sending individuals to other countries where these individuals don't have any ties to these countries all over the world. So this is also something that we're closely tracking and something for which you should always consult an attorney to see what the state of the law is, because things are changing on an almost day-to-day basis, and you need to be aware of what is happening. So we've probably talked about this before, but the Lake and Riley Act still remains, where basically not only is there mandatory detention for certain individuals based on how long they've been here and their method of entry, but also for individuals that have been charged with committing minor criminal offenses. And so that means that the judge cannot issue a bond even if they are being charged for something, not convicted just yet. So this is also something where you want to consult with an attorney before you go through and file a bond packet where you may not even be eligible for it, so that you can weigh different alternatives and see what is the best plan and course of action for your case. So things that you should always continue to think about is, for example, if maybe you have no family members that are U.S. citizens, you don't have a lawful entry, but let's say you've been subject to some extreme forms of abuse at your job, or you were a victim of a crime in the past, or you have an old petition that maybe someone filed for you a long time ago, then you should speak to an attorney to see if maybe you could pursue a T visa, a U visa, or if you can, qualify for anything based on that old petition that can help you, especially for individuals that have TPS and that have been renewing it for some, I've heard even maybe 15, 20 years. But it's very important. Talk to an attorney. All right. And things that you can do to prepare yourself, right? Actions that you can take now are just have all of your documents prepared, right? In the unlikely event that you get detained or pulled over and sent to ICE, are your family members able to easily access your civil documents, your birth certificate, your medical records, your marriage certificates, your tax documents? If you have to show that you've been here in the U.S. for 10 or more years, is all of that documentation of physical presence easily accessible where your family members can obtain it easily? So all of these documents, if you receive any psychological evaluations or things of that nature, keep it all together, all those copies in a place where you and a family member know where they can access them if for any reason you were detained. Okay, so things to track and datelines to keep. The TPS termination. So like I said, it's been extended to September 3rd. This was moved from July. The NACADA form filings, like I said, that date has passed, but still talk to an attorney and see if there's anything that can be done there. And like I said, continuing to monitor all the litigation going on with a lot of these executive actions blocking relief that has been available for individuals in the past. So now I'll turn it over to Maria to see if she has anything else to add.
No, thank you very much, Cynthia, for such an insightful presentation. And thank you, well, to all of you that have been here with us. You can follow us on our social media. We are on Facebook, X, on Instagram, TikTok, also on Blue Sky. And you can scan the QR code to sign up to our newsletter, where we are sending important information and news about immigration every 2 weeks. You can also look us up in our website at www.rubypowerslaw.com, or call our number at 713-589-2085. Then for our webinars for July, if you can go to the next slide, please. Thank you. We have been seeing the trends and updates in marriage-based green cards. We also saw the Supreme Court ruling on birthright citizenship, and we will be seeing the perm labor certification soon. So all of these webinars are on our YouTube channel. You can look them up there, and we will be uploading webinars every Friday. So hope to see you soon again. Thank you.
Thanks.